thought we would now take some questions that we've gotten, but questions that are specific about cues or clear and unmistakable errors. So this will be something of a Q&A segment. Nick and I are going to be talking about questions around what is clear and unmistakable error, how it works, and how to navigate the process if you are pursuing a benefit that stems from what you believe an error was made in the past, a clear and unmistakable error in an adjudication. This is, disclaimer, one of the most technical, very high standards and burdens area of VA law. Cues are very rare. We don't see them a ton. Nick can talk more because I think he probably sees more than I do at the court. But these are very, very discrete mistakes that have been made in the past. They're not impossible to prove, but they're very, very difficult to prove.
Yeah, I think if the rest of the VA system is, in theory, supposed to be accessible to laypersons, to non-attorneys, Q is difficult for us. So, Godspeed if you want to file a Q. I don't mean to dissuade anybody from thinking that they're not possible, but yeah, we'll get into it. It's very possible. It's just very technical. Mm-hmm. And there will be things that, just to your mind, you're like, well, this was clearly a mistake. Obviously, this was wrong. And you might be right, but that doesn't mean it hits those technical legal markers for Q. So that's kind of what we'll get into about with these questions here.
Exactly. So first question that will help us kind of explain what Q is a little bit more. What are some common examples of Q? And what are some examples of cases that are not clear and unmistakable error? So the example that comes to my mind is an example where a decision is made based on facts that were not existent or just completely not as the adjudicator presented them to be in the decision. So in order to demonstrate that a Q was made, you have to prove that adjudicators did not comport with facts as they were clearly known or apply the law as it existed at the time of the decision. And these are things about which reasonable minds cannot differ. There can be no question. There can be no one person sees it one way, another adjudicator might have seen it another way. Those are instances where Q doesn't exist. Where a Q might exist is if we see a rating decision and it says that a veteran's claim for service connection for a mental health condition cannot be approved because there was no evidence of in-service treatment for a mental health condition. If the records show that the adjudicator had at that time that there was in-service treatment notes of a mental health condition, then that might be a clearly an unmistakable error because the facts as they were in the record, in writing for everyone to see, were not adhered to, or the decision that the adjudicator rendered was not based on those facts.
Yeah, and contrast that with a case or the same case, but instead the regional office acknowledges the in-service treatment, but says that they don't think that showed sufficiently severe symptoms or whatever their rationale might be. But the fact that they addressed it and weighed the evidence, that's where we leave Q behind. And you're just not going to win on a Q motion in an instance like that. But right, in your example where it's clearly factually incorrect when they said that there was nothing in the service records, that would be Q.
Exactly. Nick, what about time limits to file a Q? Talk a little bit about that.
So short, easy answer, there are none. That is sort of, I think, one of the gaps Q is meant to fill. Normally, you have your 1 year to appeal a negative decision if you'd like to. And after that, you just have to go ahead and file a new claim. Q, though, there is no time limit. You could have a decision from 1975, right after you got out of service. And if you think that there's Q in it, you can file a Q motion 50 years later in 2025. And, if you're correct, then, you'll still be able to get that retroactively corrected. So in short, no time limit.
And another thing that's pretty liberating about Qs for all the difficulty that they pose. Filing a Q motion, and we call it a Q motion because the procedural mechanism by which to raise a clear and unmistakable error is to file a motion for revision of that decision that contains the error based on Q. So what you're doing is you're telling VA, you need to revise this prior decision that you made, regardless of how long ago it was made, like Nick described. You need to revise that decision and remove this clearly and unmistakably erroneous determination. So to do that, you do not have to file a specific form. And that's going to have an asterisk after that because I'll tell you what we do here. There is no form to file a Q motion. I think anyone who's in the VA process now knows that everything has a form that goes with it. In order to file for TDIU, you need to file the 8940. In order to file an appeal, it has to be on a correct form, and legacy versus AMA. So forms are everything. And there is no form for a Q motion, which is good. That said, one of the things that we try to do is to file a Q motion with a claim form. This is not correct. We do this because we want VA to establish what's called an end product in their systems to adjudicate the motion for Q. So we have found that if you just submit a letter that explains, I think there was a Q in this decision, it's possible that it might get sort of like lost in the mail in the sense that VA will not establish a task for their adjudicators to complete and work without a form.
Yeah, especially these days now that there are strict form requirements.
Exactly.
Back in the day, if you sent a letter in, VA was supposed to read that letter and determine what it was. Now that they don't do that with claims, yeah, I think sending some sort of form like what we do, even though it's not strictly necessary, sometimes just playing by their rules, so to speak, can just help get the ball rolling more than just sending in any piece of paper with your assertions on it.
It's kind of like bait.
Yeah.
Send the claim form, and then there's a better chance that someone will stop and figure out what needs to be done with this.
Right.
So we've gotten questions, do I have to file it on a certain form? The answer is no, but if you're noticing that you're sending in correspondence to VA and they're not picking up on it, you may want to consider a 526 EZ or even an 0995, the supplemental claim form, so that they create a tasker on their end to adjudicate the Q.
Another common question is, can I include any new evidence when filing a Q motion? And generally, what should I file or include with that motion? So the answer regarding new evidence is no. What you should be submitting with your Q motion is arguments. One of the more technical aspects of Q motions are an actual strict pleadings requirement. So you need to identify the error that you believe is clear and unmistakable and tell VA what that error was and why it was an error, as opposed to just generally, if you think your shoulder is related to service, you can tell VA that, and it's kind of then on them to go through and figure out, okay, is there anything in the records supporting that? With Q, you need to walk them there. So definitely should be submitting arguments explaining that. But if you find yourself trying to submit or point to new evidence that wasn't in the file at the time of that decision, that should raise a flag that this might not be a Q case or that you may not be successful in it. So again, there's no time limit, but if you are dealing with a 1975 rating decision, you're probably going to have to just focus on, what was in your service records in front of VA at that time, as opposed to, some treatment records from the 90s that further elucidate the condition and its onset. Those may be helpful, just generally speaking, for establishing service connection, but if you're pointing to something that wasn't in front of the adjudicator at the time, it's going to be hard to say that they made a clear and unmistakable error since they didn't have the benefit of that evidence.
Exactly. And this comes up a lot with diagnoses that are rendered later in time. In many contexts, the lack of treatment isn't negative evidence against a veteran's claim. They can supplement that lack of treatment with lay statements and things like that. But if you're looking at a decision that was issued in the past and there were no treatment notes prior to that decision, and the decision was about, let's say, an ankle, and there was just nothing at all speaking to an ankle condition, it's totally understandable that maybe a veteran's story would be, I wasn't actively treating at that time, and that's why there's no documentation. That totally makes sense. It's just that that kind of absence of evidence is not going to give rise to a Q. Nick mentioned before, this is sort of like the purpose of Q is to hold the agency accountable for very, very clear and obvious errors. But the agency can't be held accountable for what it didn't have at the time of the decision. In many cases, if evidence comes into the file later, it might show that something existed at the time of the decision, but it has to be very, very clear. No reasonable minds can differ about whether the evidence was there or whether the law was applied correctly. So that's going to be that added burden to get to the Q standard. Some have asked, how do I know which law or regulation VA did or did not apply correctly at the time of a decision? If you are struggling to figure out what law or regulation applies to your claim, there's a couple of places that you can look on your own, even if you don't have any experience in the law in this area. You can look at the list of regulations or laws that are listed in your VA decision. These are not always listed clearly, but oftentimes in a rating decision from the agency and certainly from a board decision, there will be a list of laws or regulations considered in making the decision. So you want to look at those and make sure that they were properly applied in your case. You can also find VA's laws and regulations right online just by searching for them. So you want to have the specific section that you think applies to your case. And then also it's good to remember that you're probably going to be looking at Title 38 of the Code of Federal Regulations. That's where VA's regulations lie. And we'll move on to a couple of hypotheticals because I think in the Q context, the hypos are the most common questions that we see. One that we've seen before is if I'm eligible for SMC-S, which is a special monthly compensation benefit, and VA issues a decision that does not grant it, does that count as a Q even though I didn't apply for SMC-S? Short answer is going to be no. There's no clearly erroneous decision made in this context. VA does have a duty to address things that are raised implicitly by a claimant, but in a case where an SMC benefit isn't claimed at all, it's going to be pretty much nearly impossible, I would think, to say that VA clearly erred in not addressing that which was not raised.
Yeah, sort of like duty to assist errors, reasonably raised things. VA may have been wrong in not addressing something that was reasonably raised by the record, but that falls in that gray area where VA is wrong, but they are not clearly and unmistakably wrong.
Mm-hmm.
So yeah, if you didn't specifically raise it, Q's probably not going to work out for you there.
And that is a great point that leads to another question we've seen. I believe that VA failed in its duty to assist on one of my claims. My other claims were sufficient to get me a total rating, so I didn't appeal that decision.
Right.
If I were to be reduced for some reason, could I then file a Q and get back pay on that reduction? So I think what's being described here is there was a duty to assist error with respect to a compensation and pension examination. The examination was flawed, and VA relied on that examination to reduce a veteran's rating. The veteran might later want to address that reduction if their P&T status is jeopardized in any way. And the question is, can they do that with Q?
So yeah, with Q, no. Again, it's one of those tough, we see this a lot where a veteran, they have their 100% rating and, naturally may just think, well, there's nothing more to do here. They denied that, but that doesn't really matter. This does raise the idea of like these kind of protective measures, which is really what we do a lot of as well. Even though this may not get our client additional benefits right in this moment here, it can just help protect them going forward.
Mm-hmm.
So here, yeah, where questions of whether a VA examination were adequate or, if VA did not get an examination, but you believe they should have, those are all going to fall under what we call like kind of those duty to assist questions. And those are just never going to be Q. So that's why it's really important when you're dealing with reasonably raised stuff or duty to assist questions.
Mm-hmm.
get that appeal in, whether it's a supplemental claim or board appeal or whatever it is. If you think that there was something done wrong there, appeal it within that year, because once that year is up, you're going to lose out on your ability to challenge that.
Totally right. And I think rating reductions are interesting in the Q context because, yes, it is totally right that a duty to assist error on its own is not going to give rise to a clear and unmistakable error. You may consider in a rating reduction scenario, did VA properly apply the law as it existed at the time to the reduction? Because that's an area where we see VA making pretty clear errors. Rating reductions require significant improvement or some degree of improvement in order for the reduction to proceed. And sometimes there can be an argument there that it was clearly and unmistakably wrong for the agency to decide that that improvement had been noted. But as Nick mentioned, if the improvement is noted in an exam, even if that exam is bad or the examiner wasn't paying attention to you, or a lot of things that can happen in the exam process, totally valid. Those things are just not going to rise to the level of clear and unmistakable error because those are still facts in the record.
Right.
Negative facts don't absolve the agency of, this requirement to like read in between the lines or anything like that.
Yeah. But yeah, the point about reductions, even if it's not, again, to not get too legalese or technical, but even if a reduction doesn't invoke Q, it's another super highly technical area of the law. So, Q should raise your flag, go talk to somebody, try to help figure things out. Reductions as well, for sure. Because again, even if it's not going to be necessarily Q, there's still a lot of ways to get reductions reversed and have them restored even without it. But again, a lot of times that does have to be done within the year.
Okay, a couple more. And we touched on this, but this is a very common one, so it's worth repeating. My examiner disagreed with my diagnosis, even though I had strong evidence from outside doctors. Could this qualify as Q? No, because reasonable minds could differ about the import of all of that medical evidence. So this is a classic case of VA's doctors say no diagnosis. You may obtain private information that says, we disagree. This veteran does have a diagnosis. If the agency denies that claim, it is not a clear and unmistakable error for them to do that. That is something, to Nick's point earlier, that would be great to appeal. Yeah. And that's why you really want to pay attention to your 1-year appeal deadlines. And if you get a decision that sides with the wrong doctors, let's say, in that scenario, you really want to be timely appealing so that you're not limited to making a Q argument.
Yeah. And this fact pattern here where you have, your doctor saying something and VA doctor saying something else, those can be super frustrating. And I've talked with clients where they've been trying to get, maybe I'm working on a 2020 claim of theirs, but they also had a 2010 claim and they want it back to 2010. And, I can see how frustrating it would be when, your doctor has this 5-page report talking about how your condition is diagnosed as this and it's related to service. And then, there's a couple sentences from the VA examiner and VA goes with that one instead and denies. And, your brain may just be screaming, this is so wrong. This is, clearly my condition is related to service. And you're right. But again, it's just when you're talking about doctors disagreeing with each other and VA determining which of those doctors' opinions it's going to go with, that's weighing facts that just, you need to appeal that within a year. So, yeah.
It's heartbreaking. This kind of situation is really, really trying.
Yeah. So the lesson is appeal it within a year.
Exactly.
Appeal it within a year. And then Q is just this kind of like last backstop for when there was just really no way around it. But
totally. And final question along those lines. If my Q motion is denied, can I appeal that denial? What do you think?
Yep. Yeah. So just like anything else, VA's decision on a Q motion is a decision. It's an appealable decision, just like everything else. So that's, when we don't get too many of them even at the court level, but we only get them at court because somebody appealed that decision. If you file for Q, appeal it. Or if VA denies your Q motion, appeal it. If you get a board decision denying your Q motion, I'll be happy to take a look at it and do what I can. But yep, it is definitely appealable.
And when you appeal, you're back to forms world. So even though you don't have to file a specific form, but we talked about that, to get the queue considered, once you get a VA decision on the queue, then you're back to needing to pay attention to the 1-year appeal deadline and the appeal forms that you need to file to be able to continuously pursue the benefits that were denied.